being able to be on all sides of the transaction from beginning to end, right? From the time you create the estate plan to the time somebody becomes incapacitated and then ultimately passes away, you're able to see the full gamut of the impact of what you do, of your work, or the work that maybe some other attorney did, or some other planner did, or people who go online themselves and try to do it themselves and the mistakes that they make. And so you're able to see it from beginning to end. Now, many attorneys who work in my area of practice do exclusively estate planning. That's all they do. They just want to do the transactional stuff. It's certainly, from a perspective of an attorney, it's much less stressful. You don't have deadlines, unless self-imposed deadlines. You don't have court deadlines. You don't have the stresses that come along with litigation. And being a litigator, you have to have more resources. You have to have staff. You have to have paralegals and legal assistants who help with all of that. So that's, higher overhead. So many people who work in my area of practice do only the transactional side of things, the estate planning. What makes us a little bit different, and I think what gives us an advantage, is that we're able to see, like I said, all sides of the transaction. We're able to see the result when somebody passes away. What happens with the administration? Was this plan done correctly, or are there mistakes? Are we now ending up in litigation because of mistakes that were made? Now, litigation can come about not because of mistakes. It can come out because people are just unhappy. Family members are unhappy with each other. They'll find ways to have a dispute or to fight about things. People will contest wills or trusts, even though they were properly done. They'll contest them, for settlement value. So there's certain types of litigation that no matter what you do, you're not going to be able to control. You can't control what other people do at the end of the day. But many of the reasons that we're in court, either because there's disputes or because the documents are not done correctly. So when we're in court, it's not always because there's litigation going on between the parties or there's this dispute. It's because things were not done correctly. The documents don't accurately reflect what was intended. Maybe they're ambiguous. Maybe the trust was not properly funded, and now we have to go to court to resolve these things. So there are many reasons to be in court. But because we see that too, we get to see the end result of that, and we deal with these problems, like you said, on a daily basis. It makes me a much better planner. I now have experienced many of the things that people, when I meet with, talk to me about, right? Blended family situations where when somebody dies, what the issues, the disputes, the problems are going to be. So in the planning, I make sure that I do things within the plan to minimize the possibility of those things happening, right? To anticipate them. And so it makes you a much better planner when you're able to translate what you do in court versus the transactional side of your practice. So I think it gives us an advantage over many other firms who just do estate planning.